Mr. Chair, Commissioner Dufresne, the Prime Minister recently struck a deal with Xi Jinping to allow for the import of 50,000 Chinese EVs annually. He did so notwithstanding serious concerns regarding national security, regarding privacy concerns, including audio and video surveillance, as well as tracking people's movements. Premier Ford has characterized these EVs as spy vehicles. Others have also characterized them in the same way. The U.S. has a functional ban on vehicles that contain Chinese software. So in the face of these very serious concerns that go directly to the privacy of Canadians, did the Prime Minister's office or the Minister of International Trade or anyone in the government consult with your office about these concerns before striking a deal with Xi Jinping?
We were not consulted about this trade effort with China.
Thank you for that. About an hour ago in the House, the minister responsible for AI indicated that the government would be tabling updated PIPA legislation in the near future. Have you been consulted about that updated legislation?
Yes, I have. Myself and my team have been in communications with the department, and I'm pleased with how those exchanges have gone. Okay,
and do you expect that PIPA, the updated legislation, will give you the order-making power that you said moments ago that you need and that you do not have?
Well, that's going to be up to the government tabling the legislation. But my expectation, my hope, what I can say is I've made very clear to the government and to the House and to Parliament that this is one of my top priority recommendations, that I need a stronger enforcement power, and I am optimistic.
Okay. Changing gears a little bit, the Supreme Court, in its jurisprudence, in the Spencer decision, in the Bykovitz decision, has been clear. Access to personal information or personal data requires prior judicial authorization, correct?
In criminal cases and in administrative law cases, it wouldn't necessarily be the same.
Sure. Now, under the Liberal government's so-called cyber security bill, the Minister of Industry has the power to order a telecommunications service provider to collect, retain, and share with the minister things such as metadata, subscriber account information, website visits, the location of financial data, among other personal information, correct?
Yes.
Okay. And constitutional jurisprudence has recognized that metadata such as internet browsing activity is highly sensitive personal information that is protected by Section 8 of the Charter, that everyone has the right to be secure against unreasonable search and seizure, correct?
That's my general understanding of that jurisprudence, and under my legislation, sensitive information is entitled to higher levels of protection.
And that's because metadata can reveal a lot about someone's online activities and their personal life, among other privacy issues, correct?
Yes, the Supreme Court in Bykovitz talked about that, how much you can glean from this type of information.
Right. And Bill C-8 does not require the Minister of Industry to obtain prior judicial authorization as a precondition to ordering the collection, retention, and sharing of this highly sensitive personal information, such as metadata, does it?
No, it does not. This is not in a criminal context, and I should say that I appeared before the SICU committee on C-8 and shared my recommended amendments to C-8, which include necessity and proportionality framing for the exercise of those powers.
And do you believe that there should be a requirement for the minister to obtain judicial authorization? Should it be narrowed, as opposed to as it is currently written, in which the minister would have really broad powers to order the collection, retention, and the transferring of privacy information that the Supreme Court has been very clear about requires judicial authorization?
Right. Well, in my testimony, I highlighted that there is a balancing between the national security objectives, but that this is where necessity and proportionality become important. So in some parts of the bill, I highlighted that you only had necessity or
And so it would be fair to say at present it's not fully adequate from the standpoint of protecting Canadians' privacy interests. There's room for improvement.
I've made recommendations on the standard. I've made recommendation on information sharing agreements and also on notification to my office in cases of breaches.
Thank you, Mr. Cooper.
You have 3 minutes.
Government's cyber security bill, in addition to not requiring judicial authorization before the minister can order a telecommunications service provider to turn over metadata, subscriber account information, website visits, the location of financial data, and other personal data. The bill, as you noted, and those powers do not require that it be necessary and proportionate, that the current standard is a relevance one of relevancy, correct?
Correct for one of the powers. There's a number of powers in the bill.
I'm talking about under 15, paragraph 15. Okay. And can you, so that is a pretty permissive standard.
It's much more permissive than necessity and proportionality, which is why I've recommended that it be changed to that.
Yeah, so no judicial authorization and no necessary and proportionate standard. We're talking about some pretty significant information and data concerning the privacy of Canadians. One of the, I would characterize it as excuses that the government has put forward when privacy concerns have been raised with regards to this bill is that they have said, well, there's a lower expectation of privacy with respect to engaging in a regulated activity. And that's true. There is a lesser expectation or reasonable expectation of privacy, but I just want to confirm that when it comes to the internet, that is not a regulated activity, is it? In fact, it engages significant privacy expectations.
Well, in this case, I have not called for there to be a warrant or a judicial authorization, but I have called, and I am calling for a stronger threshold, which should be, in my view, necessity and proportionality.
Right, but I'm also just saying that this is an activity, the use of the internet, metadata, all of these things based upon judgments of the Supreme Court engage significant privacy expectations. That's a fair statement, isn't it?
Well, I think it's enough to warrant necessity and proportionality as the standard, so that you assess, do you need it? How much do you need? Don't get more than what you need, but also have you looked for less privacy impacting mechanisms?
Okay, thank you, Mr. Cooper.